What if the very halls we, trust for justice were operating on a different ledger, where liberty is traded and rights are, well, a currency? We often think of courts as these cornerstones of law, but what if, as one author is claiming, they've become something else entirely? Today, we're taking a deep dive into some really provocative material. We've got excerpts here from a compelling news source, The Watchman's Warning and The Legal Cartel Dossier by Elias Cromwell. And these aren't just articles, They really represent a direct challenge to how many people perceive the American legal system.
Yeah, absolutely. Our mission today really is to unpack Cromwell's pretty intense claims. He argues that justice has become commerce, right? Not the rule of law.
Yeah,
and that citizens, incredibly, are its currency. So we'll explore his evidence, his arguments about this alleged legal cartel. We'll look at the mechanisms he describes and maybe touch on the tools he suggests for citizens to push back. This whole deep dive, it's really aimed at arming you with knowledge, offering some new perspectives, and helping you understand what all this could mean for the idea of, well, a free republic.
Okay, let's unpack this then. And just to be clear, this deep dive isn't about giving you specific legal advice for, your situation. It's more about providing a broader understanding of how the system allegedly operates, according to Cromwell, giving you maybe a clearer perspective to navigate these complex situations. So what does this all mean for you, the individual, and your rights? Let's try and find out. Cromwell really wastes no time in his Watchman's Warning. He states it bluntly. They will tell you the system works, but I have walked their corridors. I have seen the robed merchants who auction your rights. He goes on, this is not justice, it is commerce. It's not the rule of law, it is the rule of profit. That's a powerful opening shot, isn't it? What's the core idea he wants us to get?
He really wants to completely reframe how we view the system. The core insight here, I think, and what Cromwell is challenging us to consider, is that he sees the legal system not as this neutral place for justice, but as an economic engine. He's not just, critiquing a few bad apples. He's suggesting the fundamental incentives are just wrong, driving profit over principle. This idea of justice being a commodity, something bought and sold rather than a right, that's his central argument. He even says the dossier itself was born from necessity, not choice, after seeing, in his words, too many patriots walk into a courtroom believing the law was on their side, only to be devoured. And Cromwell emphasizes, like you said, this isn't a legal advice book. He calls it a lantern in a darkened courtroom. The aim is to reveal the anatomy of the beast, as he puts it, and the collusion between the courts, the bond monopoly, and the federal funding schemes that have turned justice into industry. So this naturally leads us to ask, okay, how does he think we got here?
And he points right at what he calls the unholy bar monopoly over justice. Describes it as a closed guild of gatekeepers, even the legal cartel. He's talking about state bar associations, obviously.
Exactly. And if we connect this to the bigger picture, Cromwell argues the founders' beliefs are absolutely critical here. He explicitly states the founding fathers despised monopolies, especially over justice. He brings up Thomas Jefferson, warning that it is the trade of lawyers to question everything, yield nothing, and to talk by the hour.
Right, the classic lawyer stereotype almost.
Sort of, yeah, but Jefferson saw it as a real threat to liberty when organized into guilds. And James Madison also warned about the accumulation of all powers, legislative, executive, and judiciary, in the same hands. Madison called that the very definition of tyranny. So this historical context, it provides Cromwell's framework. He's suggesting the current system, as he sees it, has drifted pretty far from those founding principles.
Okay, so if that's the premise, justice is commerce, the Bayar is a cartel, how does Cromwell argue this actually operates? He introduces this really striking concept he calls lawfare. Sounds intense. How does he define that?
Oh, he certainly pulls no punches there. Cromwell frames lawfare not just as, regular legal fights, but as a deliberate strategy. He calls it the weaponization of law against the people, against truth, and against the very republic it was sworn to protect. He even says, flat out, we are at war.
Wow.
He describes it as politics by litigation, essentially a strategic abuse of the legal system to, silence dissent, bankrupt opposition, control political outcomes, even criminalize patriotism, and really disturbingly destroy families. And he names specific groups he believes are targeted. Pros say litigants, that's people representing themselves.
Right, without a lawyer.
Exactly. Plus whistleblowers, political outsiders, parental rights advocates, independent journalists. He claims the court sort of let it happen because, in his view, judges are appointed, not elected, and are bar members first, public servants second.
And this, according to Cromwell, leads us to something he calls the shadow courts. administrative law, and the erosion of justice. He presents these as creatures of the executive branch, not the judicial, operating across, well, a huge range of government functions: family law, tax boards, licensing, you name it. They look like courts, where the trappings of justice, he says, but allegedly lacks the constitutional protections.
Right. These administrative tribunals, according to Cromwell's analysis, bypass core constitutional protections. He cites several alleged constitutional violations. First, a separation of powers breach, specifically Article 3, which, sets up the independent federal judiciary.
Okay.
Then a lack of jury trial, which he links to the 7th Amendment. Also, appointments clause violations, and here he references a real case, Lucia v. SEC, where administrative law judges, ALJs, were found to be improperly appointed officers. And finally, due process violations, because of what he calls inherent bias when the judge, the adjudicator, is actually an employee of the agency bringing the case. Cromwell stresses that the legal cartel's interest, as he puts it, in these courts is all about speed and control, generating revenue and facing low resistance, because most citizens don't realize they can challenge the court's jurisdiction.
So if lawfare is the weapon and these shadow courts are the battleground, where does Cromwell argue this system really makes its money on people's problems? He turns to the family courts. He labels them, quite chillingly, the coldest room in the Republic. Claims that bureaucrats and bench warmers alike have learned to monetize misery there. The official line is the best interests of the child, but he says the reality is a cash for kids pipeline.
Yeah, this is a really critical claim in the dossier, and he roots it in specific federal funding streams. Title 4D, which is about child support enforcement incentives, and Title 4D tied to foster care and adoption placements. The allegation in the dossier is stark. The more parents they separate, the more children they remove, the more support orders they enforce, the more federal money, allegedly, flows into their coffers.
A direct financial incentive.
Exactly. This financial incentive, Cromwell argues, violates the Fifth Amendment's due process clause. It basically turns the courtroom, in his words, into a market stall.
And the dossier apparently includes testimonies from the Republic and case studies to back this up.
It does. He provides examples. Like in Wyoming, he claims a family trust was trampled and a trustee forcibly removed without notice, due process, or standing because its immunity, its structure, supposedly threatened the incentive stream. In California, there's an account of a whistleblower reporting Child Protective Services workers receiving gift cards and bonuses for successful adoptions.
Gift cards.
Wow. Yeah. In Texas, he mentions a combat veteran whose wages were garnished at over 65% by what Cromwell calls an admin tribunal disguise. And in New York, he highlights whistleblower Christopher Lithman, who allegedly uncovered judicial conspiracies involving custody rackets and money laundering through Title 480. Cromwell presents these not as, one-off problems, but as patterns. Patterns of judicial collusion, weaponization of Title 4 DVE funding, and administrative courts circumventing constitutional protections.
Which brings up the whole issue of accountability, right? How does anyone fight back if judges are protected?
Exactly. And that leads to what Cromwell calls immunity as invisibility. He argues that judges are untouchable unless gross corruption is proved, and even then, that bar is nearly unreachable. He cites some pretty stark historical cases. Stump v. Sparkman from '78, where a judge who ordered a forced sterilization was granted immunity.
Unbelievable.
And Pearson v. Ray back in '67, where a judge who jailed civil rights demonstrators was also protected. His conclusion is blunt. A system that permits abuse and forbids consequence is not a court. It is a monarchy in black robes.
A monarchy in black robes. Okay, so moving on from the courts themselves, Cromwell dedicates a lot of space to the bar empire licensing liberty itself. He says, when a trade guild becomes the gatekeeper of justice, justice ceases to be free. He really views the bar, the state bar associations, as a syndicate hidden in plain sight, controlling who speaks in court, what arguments get heard, even influencing who becomes a judge.
Right. And digging into this, the dossier argues there's a sort of myth of the state-issued license to practice law. Cromwell claims state legislatures haven't actually passed specific laws for individual law licenses. Instead, he says, state Supreme Courts delegate this power to integrated bar associations, which, he alleges, often function as private corporations.
So not a direct government license in the way people might think.
That's his argument. And he points to the First Amendment, reminding us it protects the right of individuals and organizations to give legal advice, citing NAACP v. Button from 1963. The implication, according to Cromwell, is that legal advocacy should be seen as protected speech, not just some licensed economic activity that the BIR can totally control.
Okay, so how does he claim the BIR suppresses dissent then?
He outlines a few ways. First, silencing the sovereign people, basically, treating people who represent themselves, the pro se litigants, as if they're ignorant or even acting in contempt of court.
Right.
Second, weaponizing legal jargon to deliberately confuse people. And third, engaging in lawfare against dissenters, using the legal system itself against those who challenge it.
And this ties into that label you mentioned earlier.
Exactly. The slur of sovereign citizen. Cromwell calls this a weaponized label, used by the cartel, his term, to ridicule and silence people who question things like jurisdiction or due process. The idea is to dismiss them without actually addressing the substance of their legal arguments.
Just slap a label on them.
Pretty much. And he points out that even federal courts have recognized issues with this term. He cites United States v. Benabe calling it legally meaningless, United States v. Davis calling it prejudicial, and Doe v. FBI calling it improper. So Cromwell's point is that the label itself is a tactic, not a real legal category.
All right, so Cromwell paints this, well, pretty challenging picture of the system. If things are as he describes, what does he propose people actually do? His message seems to be, anger alone will not reclaim the republic. Only knowledge, resolve, and lawful defiance will. So what are these specific actions? What can citizens do?
Well, the dossier does offer a range of what he calls defensive strategies for citizens. First, specifically for challenging those administrative courts we talked about, he provides direct, quick objection phrases, like literally scripts for people to use.
Oh, really? Like what?
An example he gives is, objection. This tribunal lacks Article 3 judicial power to adjudicate my rights. I demand transfer to a court of competent jurisdiction. And he really stresses documenting these objections, getting them on the record for potential appeals.
Okay, that sounds practical. What else?
Second, he talks about agency principles. He defines government officials, judges included, as agents working for we the people, we're the principal, they're the agents. He argues any actions they take beyond their specific delegated constitutional powers are ultra vires and void.
Ultra vires, meaning?
Beyond the powers. Like an employee doing something completely outside their job description, the company wouldn't be bound by that. Same principle, he argues. A sample objection he offers for court is, this officer of government is but an agent of the people, bound by the Constitution as his charter of authority. Any act beyond that charter is ultra vires and void.
That's a fascinating way to frame the relationship between citizens and officials.
Yeah.
What other tools does he suggest?
Another key strategy he highlights is something he calls the Achilles heel, the bonds that bind the robe. This one's interesting. Cromwell suggests there's a sort of hidden chain on every public officer. It's called a surety bond.
A bond, like an insurance policy.
Kind of, yeah. He claims every official, from a court clerk right up to a judge, allegedly has this financial guarantee ensuring their lawful conduct. So, if they abuse their authority, Cromwell says citizens can file a claim against this bond, and if the claim is successful, it could potentially lead to the bond being canceled, and maybe even the official losing their job.
That sounds powerful, if true. Does he offer help with that?
He apparently provides a surety bond claim kit for this very purpose in the dossier. And beyond that, he advocates for bigger structural changes, like abolishing the bar monopoly, ending mandatory bar membership, stopping the bar from overseeing judges, repealing state bar statutes he sees as granting improper power, and restoring the right to common law representation.
So these strategies, and he mentions others too, like looking into the Emoluments Clause, Ferretora, the Foreign Agents Registration Act, and using federal civil rights lawsuits. He frames all this as lawful resistance.
Yes, entirely lawful resistance. He states very clearly, resolve is not violent, it is immovable, it is peaceful defiance with eternal weight.
And he keeps bringing it back to the founders, doesn't he?
Constantly. He uses their voices against tyranny, as he puts it, like ammunition. He cites Jefferson warning against judicial usurpation and lawyers as a cartel class. Hamilton cautioning about the judiciary, even though it's the least dangerous branch. Yeah. Madison, again, warning against factions and the accumulation of all powers. Adams emphasizing a government of laws and not of men.
Right.
And Benjamin Franklin's famous warning, those who give up essential liberty for temporary safety deserve neither. These historical touchstones, they provide this powerful framework for understanding the modern challenges Cromwell is outlining.
Okay, so looking ahead now, Cromwell also turns his attention to the future, describing something he calls the digital court, the final stronghold of the global cartel.
Yeah.
He calls it a quiet revolution disguised as efficiency, where the courtroom basically becomes digitized, privatized, and centralized. What's the main worry here?
Well, he alleges a connection to what he terms a global cartel, mentioning the World Health Organization, the WHO, and the UNWEF Global Governance Pipeline. He suggests a future where access to justice might become dependent on obedience to a global administrative order, maybe through things like digital IDs or central bank digital currencies, CBDCs, which we're hearing more about.
So your ability to use the court depends on your compliance score, almost.
That seems to be the fear he's expressing. He outlines what he calls the cartel's version of this digital court. Things like account-based justice, virtual-only hearings becoming the norm, maybe even algorithmic adjudication letting AI decide cases.
Wow.
Evidence treated just as data, pay-to-play remedies, non-transparent systems. He argues this would lead to a serious Article III erosion, undermining jury trial rights, First Amendment petition rights, fundamental stuff.
He calls it a constitutional eclipse, designed, he argues, to silence dissent and enforce global edicts that local communities couldn't repeal. It's a very stark vision.
It is. And to counter this potential future, Cromwell proposes what he calls non-negotiable guardrails for any digital tools in court. Things like a human jury and judge must always be the default option. Any software code used has to be open source and auditable. Complete evidence transparency. No secret vendors running the tech. Also, guaranteed in-person access must remain, independent oversight, and the right for someone to have a specific hearing to challenge the validity of the digital model itself, a model challenge hearing.
Right. Checks and balances for the digital age.
Exactly. And he finishes that section with a really stark warning from Cromwell. If the courthouse door becomes a login screen, liberty will be no more secure than a forgotten password.
A sobering thought. So we've taken quite a deep dive here into Elias Cromwell's The Legal Cartel Dossier. We've explored his claims, and remember, these are his claims that the American legal system has shifted into this profit-driven enterprise. We looked at the allegations of lawfare, the rise of these so-called Shabbat courts, the financial incentives he describes in family courts, the role he assigns to the bar, and even this potential future threat of a digital court. Cromwell's core message, it seems, boils down to this. The courtroom is not the enemy ignorance is.
Indeed. And his ultimate call seems to be for resolve or ruin. He states, quite powerfully, the Republic stands not on parchment, but on the courage of its people to uphold what was written there. He asserts that resolve is when a free people say, no more. He's urging action, but action through knowledge, through documentation, through lawful, peaceful defiance. As he concludes right at the end in the dossier's epilogue, the gavel is in your hand now. Render your judgment.
It's definitely a powerful call to action. It challenges us, really, to look at the very foundations of our legal system with, perhaps, new eyes. This deep dive has certainly presented a perspective, Cromwell's perspective, that suggests maybe a fundamental reevaluation is needed. So the question Cromwell leaves you with is, what will you do with this knowledge? Will you demand transparency, question authority, work to restore what he calls a government of laws, not of men? Puth, the choice, as he argues it, is yours.